Envoy in the Obama administration for genocide-related affairs, one of the leading thinkers in the United States on the complex of issues that we're addressing here. Emanuela-Chiara Gillard from the Oxford Centre on Ethics and War, who's I thought was going to be Victor Ludorum today for distance travelled from Rome, but in fact Ambassador Buchwald wins that prize. Ken Macdonald is former Lord Macdonald of River Glaven, momentarily delayed, but will be here, former DPP, much to say, and Lord Verdirame KC, one of the most distinguished practitioners of public international law. Usual House rules will obtain no question too outrageous. You just have to state your name and organisation first. We look forward to a long, healthy, memorable discussion. I notice members of the Fourth Estate here, so we hope that they will give it maximum publicity of the most favourable kind. Thank you.
An awful lot of matters of some controversy. But there is no doubt that the International Criminal Court is very much in the news at the moment, and we all know why it's in the news. The question of the arrest warrants for Israel and Gaza are the occasion for this discussion. But I hope as we proceed through the remainder of the morning, we might raise our eyes from the detail of that, because the International Criminal Court is engaged in investigations into a wide range of other matters. Greetings, Ken.
I'm so sorry I'm late.
No, don't worry.
Difficulties of parking a Lime bike around here.
Ah. Okay, well, you have the advantage of me on that.
I'm very sorry to everyone for being late.
That's all right. So I hope that we will be able to have a good discussion as the morning goes on. Now we've got a good turnout in the room, but I think we have upwards of 100 people who are joining us online. And when the time comes for questions, I'll try to take some questions from the room and some questions from our online attendees. Now, Lord Godson has briefly explained the distinction and background of our four panellists, and so I shan't repeat that. I think all of you had more detail in the various flyers that went out from Policy Exchange, and so it would be an unwanted use of time to rehearse that any further. I suspect also that many of you here know a great deal about the International Criminal Court and what it's been doing in the years since the Rome Treaty was adopted in September 1998, and the court eventually established from the 1st of July 2002. The judges didn't come along for nearly another year after that, and I think its first warrants were issued in July 2005. I'm not going to go into any detail about the totality of its activities, but you'll remember that an awful lot of the early cases arose from conflicts in Africa, and that generated its own controversy at the time, because there were some comments that the court was Eurocentric, Western-centric, and was focusing too much on the third world rather than on the activities of some first world countries. So those are background controversies that have touched the activities of the court. Another striking feature of the court is that there are some very big players in the world who have never signed the treaty, still less ratified it or later acceded to the ICC, and that includes the United States, and in a little while I'm going to invite Todd to explain a little bit about the background to that. It includes China, of course, and also India, and the Russian involvement has come and gone, but it's gone. So it's a court which doesn't involve, to a great extent, the two biggest economies in the world, the two superpowers, perhaps one should call them, in the world now, and also the two most populous countries in the world. And there's a large number of other countries that have not acceded. So it's a very interesting jurisdiction. There has been controversy, and it's been accentuated recently. And so what I'm going to do is to ask each of our panelists to say a few words, bringing their particular expertise to bear at the outset, and then we'll have something of a discussion and come for questions. And I'm going to start by asking Guglielmo to explain a little bit about the ICC and its jurisdiction.
Yes, thank you very much, Ian, Lord Burnett. It's a pleasure to be here. I thought I would focus my remarks on the jurisdictional question on which the United Kingdom had sought permission to intervene before the election. The new government decided not to go ahead with that intervention, but a number of other states and other actors have submitted interventions. It's an interesting question because it allows us really to reflect more widely on the future of the ICC and on questions of jurisdiction. There was some public commentary that suggested, wrongly in my view, that the UK intervention was going to focus on a technicality and that it was going to advance hopeless arguments, but I disagree with that. I think it was an important issue with significant ramifications for the court and for international law. The issue is whether the court can exercise a jurisdiction over Israeli nationals in circumstances where Palestine cannot exercise that jurisdiction because of the Oslo Accords. The background to that question is the decision in 2021 by Pre-Trial Chamber 1 of the ICC. In that decision, the Pre-Trial Chamber ruled by a majority of 2-1 that Palestine qualifies as a state for purposes of Article 12.2a of the ICC statute. That is the provision that identifies preconditions for the exercise of the court's jurisdiction, and the specific precondition in question is that the state on the territory of which the conduct occurred has to be a party or has to have accepted the jurisdiction of the court. The pre-trial chamber said Palestine is a state for the purposes of the statute, for the purposes of this provision. And they made it quite clear, the majority, that they were not deciding the wider question of whether Palestine is a state as a matter of general international law under the international law criteria on statehood. The pre-trial chamber also said that the territories in question were the territories occupied by Israel after 1967, but the court also said that it was not intending to rule on any future border dispute resolution by Israel and Palestine. So the majority was really trying to strike a very difficult balance, and this is how they decided to resolve it. So Palestine is a state, but only for the purposes of the statute. That's the territory, but we're not saying anything about how this dispute may be resolved by Israel and Palestine in the future. And in the same ruling, the court, the pre-trial chamber said, we don't need to look at the Oslo Accords now, because that question is not relevant to the commencement of an investigation. It may become relevant later, but we don't need to decide it now. And I think anyone who's really interested in the legal detail of this decision should read Todd's excellent submission to the court in 20, and also the dissenting opinion by the Hungarian judge, Judge Kovacs, which is extremely well argued in my view. I think that compromise, a state but only for the purposes of the statute, Oslo Accords, we'll look at it later, was always going to be problematic, and I think the UK request to intervene brought that difficulty into sharp relief. ICC jurisdiction has normally been understood as based on a delegation or transfer of jurisdiction from sovereign states to the International Criminal Court. As part of its sovereignty, a state has the right to exercise criminal jurisdiction over its territory and over its nationals. By becoming a party to the statute, the state transfers a portion of that criminal jurisdiction to the International Criminal Court. And that agreement to transfer part of its criminal jurisdiction is also subject to a very important principle, which is really central to the architecture of the court, and that is the principle of complementarity, which is set out in Article 1 of the ICC statute. And it says the ICC shall be complementary to national criminal jurisdiction. So the question that the Oslo Accords issue raises is whether Palestine could have transferred a jurisdiction that it did not possess under or by effect of the Oslo Accords. And I think there are two important points briefly on the Oslo Accords. The first one is that those accords, for better or for worse, continue to function as the legal framework for the governance of the occupied Palestinian territory. Both Israel and the Palestinian Authority acknowledge that. They remain the basis on which the parties manage their relations, and insofar as there is a hope of a peaceful settlement of the overall dispute in the future, the settlement will have to go through the Oslo Accords. So there was again some commentary in the press that suggested the Oslo Accords are dead letter. That may be a legal judgment, but in a legal sense they remain acutely relevant. The second point is about the Oslo Accords, and I can't really go into the detail of that, is that as a result of various provisions in what is known as Oslo I from 1993 and Oslo II in 1995 and some protocols to Oslo II, the Palestinian Authority does not have jurisdiction over Israeli nationals. So if it didn't have the jurisdiction, the argument is it couldn't have transferred it. And if it doesn't have it, how can complementarity ever operate? Because the national criminal authorities in question here cannot exercise jurisdiction as a result of the Oslo Accords. At least the Palestinian national authorities, Israel is not a party to it. That's perhaps a separate question to which we might return. So I think it's a very important question, the one on which the UK government was going to intervene, and it raises at least three issues of fundamental importance for the future of the court, for the future of the international legal system. The first one is complementarity. Complementarity is predicated on the existence of an available national criminal jurisdiction. No delegation of jurisdiction was conceivable under the architecture of the ICC in circumstances where the relevant national authorities had no jurisdiction to begin with. Second, I think, point of general significance, peace versus justice. Israel-Palestine is a very complex political dispute. In circumstances where the pretrial chamber had been so careful not to adjudicate on the question of statehood in a general sense, is it really right for the ICC to drive a coach and horses potentially through the Oslo Accords by completely ignoring the way in which those accords had decided to allocate jurisdiction? And the third, I think, point of general significance is the certainty, predictability of the exercise of jurisdiction by international courts or tribunals. The principle of state consent governs the jurisdiction of international courts or tribunals. Bootstrapping, expansive interpretations, or sometimes called pushing the boundaries, are things that fundamentally undermine the legitimacy of the system, and they're contrary to the very essence, the very first element of the rule of law, which is clarity, certainty, predictability. And to conclude, I think the ICC has enjoyed in this country and still enjoys a lot of support across the political spectrum, and I think that is a good thing. But at the risk of ending on a sort of inter rorem submission, which judges never like from counsel, I think this really is a very testing moment. And how the court decides this question will have a very significant impact on its future and also on the international system as a whole.
Thank you very much. Just before I move on, do we know when the court is going to deal with the submissions that it's got, and when it's likely to rule on this?
I don't. The submissions were all filed in August, and there are
Yes.
about, I think, 60 or 65 of those.
Yes, it's quite a read.
Yes, it's quite a read, and they're only 10 pages in length, and probably quite a lot of arguments will be similar. But I don't know if they're going to have a hearing. I haven't heard whether they're going to have a hearing. They could decide without a hearing, or they might have a hearing. I don't know.
Oh, well, we'll all keep an eye out for that. Well, thank you very much indeed for that. Can I now ask Emanuela to follow on that? And of course, you have huge experience in the practical application of international humanitarian law, and I know you have concerns that there are misunderstandings in the public mind, perhaps in political minds and the press minds, about what the ICC actually does.
Great. Thank you very much. And it's really a privilege to join this panel and to be before you today. Following on from Guglielmo, I am going to raise some additional legal questions that go to the law that underlies the prosecutor's request. I'm going to first say a few words about the laws of war, also known as international humanitarian law, and their relation with war crimes. And then I'm going to comment on two aspects of the prosecutor's request. One comment is on a charge that surprised me by its presence, and the other on a charge that surprised me by its absence. Now, first, as a general point, it's important to understand that war crimes are different for crimes under domestic law. Crimes under domestic law constitute, and I'm simplifying, the entirety of an offence. War crimes, on the other hand, don't have the same independent existence. War crimes are serious violations of international humanitarian law, of the laws of war. This means that in order to interpret a war crime, it's necessary to understand what the underlying rules of international humanitarian law say. Now, why am I saying this today? Because I think it's important to understand this, but also because it is particularly relevant, I think, for the prosecutor's first charge against Netanyahu and Gallant, which is starvation of civilians as a method of warfare. And this is the charge that surprises me by its presence. Why? As I've said, a war crime is a serious violation of IHL, international humanitarian law. To understand what the war crime covers, it's necessary to go back to the underlying rules. We've got to continually do this. And despite the apparently broad title of the provision, the prohibition of starvation of civilians as a method of warfare is actually very narrow in scope. And importantly, the mere fact of severe food insecurity among civilians does not mean that there's been a violation of the prohibition of starvation. So let's look at what the law says briefly. The prohibition is found in Article 54 of Additional Protocol 1 to the Geneva Conventions. It contains two distinct prohibitions. They share the objective of reducing the risk that civilians will suffer from starvation during conflict. They also share important limitations. Essentially, the prohibitions only cover conduct that has the specific purpose of depriving civilians of goods for their sustenance value. I'm only going to focus on the first prohibition because it seems to be the one that's most relevant to the charges. And this is a general prohibition of starvation of civilians as a method of warfare. And a key question that has come up in the debates is whether the prohibition only applies when the purpose of particular conduct is starvation, or whether knowledge that starvation of civilians is likely to occur as an incidental result of a particular method of warfare is also prohibited. Now, if you actually look at the negotiations of what became Article 54 of Additional Protocol 1, subsequent state practice, which is reflected principally in military manuals, but also statements made during the negotiations of the ICC statute, as well as the elements of crime for this particular crime in the ICC statute, it is the first, narrower approach. The prohibition of starvation of civilians as a method of warfare, and consequently also the war crime under the ICC statute, only covers conduct that has the specific purpose of starving civilians. If we look at the ICC war crime a little bit more, the definition of the war crime of starvation includes willfully impeding relief supplies if it's done to intentionally deprive them of objects indispensable to the survival. So this brings into play a second set of rules under international humanitarian law, those regulating humanitarian relief operations. And if you actually look at the prosecutor's request, it seems to indicate that he is focusing on the restriction on humanitarian activities as a basis for this charge. But again, let's look at what international humanitarian law says about relief operation. The war crime refers to willfully impeding relief supplies. This is not wording that appears in the relevant treaties. There's a disconnect. I think it's important to bear in mind that not every impediment to humanitarian relief operations is a violation of IHL, even if it's willful. Belligerents unlawfully impede humanitarian relief operations when they fail to comply with the obligation to allow and facilitate rapid and unimpeded passage of supplies, equipment, and personnel involved in relief operations. However, IHL only lays down a very small number of specific measures that must be taken to allow and facilitate. Belligerents mustn't divert relief from its intended purpose or delay its forwarding, except in cases of urgent necessities. And restrictions may be imposed on the activities and freedom of movement of humanitarian relief personnel only in the event of imperative military necessity, and even then, only temporarily. Significantly, though, there is a quid pro quo in this. Belligerents, so parties to an armed conflict, are entitled to prescribed technical arrangements for the passage of relief consignments. Yes, they must allow and facilitate them, but are entitled to adopt measures of control. These could be searches to ensure that the goods are exclusively humanitarian. They may be requiring humanitarian actors to take particular routes at particular times to ensure that passage doesn't hamper military operations and isn't endangered by them. They might make the passage conditional on oversight of the distribution by some independent agency to ensure the goods aren't diverted. All of this sounds very familiar to some of the challenges faced in Gaza today. So delivery of assistance in Gaza since October has faced a multitude of complex challenges that are constantly involving the fact of ongoing active hostilities. This is immediate danger to humanitarian personnel. And this has in fact led to self-imposed restrictions by UN security officers. Rightly so, the state of the road. Initial very severe limitations on the entry of goods into Gaza, and subsequently time-consuming searches and limitations on items that can be brought in. Restrictions imposed by Egypt. Egypt also has an obligation to allow and facilitate relief operations. We have seen looting. There has been severe insecurity during some attempted distributions. And all of this is due to the conduct of a number of different actors: Israel, Hamas, the UN agencies' own security measures, the breakdown in security. All of these have a severe impact on civilians' access to basic goods. But are they a violation of the obligation to allow and facilitate rapid and unimpeded passage, and therefore amount to unlawful impeding for the purpose of the crime? I'm not so sure. we're in a situation where the ICC war crime of starvation is based on two sets of rules of international humanitarian law that are far more complicated and less protective than what appears to be the case prima facie, if you just read them. Prohibition of starvation, obligation to allow and facilitate. For these reasons, it's been interesting, the prohibition of the war crime of starvation has never been the basis of international prosecutions to date, and understandably so. This is why it was surprising to see it as the first charge in the request. That was complicated as a matter of law and fact. Let me conclude with something a lot simpler, and this is the charge that surprised me by its absence. The prosecutor's request covers conduct from at least 7th of October 2023, and according to official IDF figures, there have been over 13,000 missiles from Gaza into Israel from 7th of October to the month after the prosecutor's request. The prosecutor's request includes a charge against Netanyahu and Gallant for intentionally directing attacks against a civilian population. But why isn't there a similar charge against the Hamas defendants in view of the 13,000 rockets into Israel?
Thank you very much indeed. Well, that was a fascinating exposition of the realities of the starvation provision. Next, I'm going to ask Ken Macdonald to say a few words. Ken, of course, was Director of Public Prosecutions here for a number of years, 5 years. And I expect we'll have some observations to make about the role of prosecutor at the ICC.
Yeah, thank you, Ian, Lord Burnett. I'm going to be relatively brief, and I want to start by making clear, in case what I'm going to say in a moment is misunderstood, that I personally have no problem at all with the idea of an international criminal court. It seems to me that functioning correctly, it represents an assault on impunity, and in that sense is an appropriate part of a rules-based international order. So I have no problem with the idea of an international criminal court. Of course, its jurisdiction has to be limited to the gravest crimes as it is, and the principle of complementarity must be paramount. That's to say, its jurisdiction should only be invoked where sovereign states are unwilling or unable to bring proceedings for such grave crimes in the face of credible evidence. So that the ICC complements local justice rather than replaces it. And I'll return in a moment to the important question as to whether the state of Israel really falls into the category of a state unable or unwilling to investigate appropriately and, if necessary, prosecute such crimes. I also want to make clear how strongly I personally deprecate Prime Minister Netanyahu's recklessly offensive comparison between the ICC and the Nazi People's Court of the 1930s. And I equally deprecate his reckless characterization of Karim Khan, the ICC prosecutor, as, quote, one of the leading anti-Semites of modern times. This was an offensive and, in my view, shameful thing for the Prime Minister to say in the absence of evidence, and perhaps wouldn't have been made had Mr. Karim not been a Muslim. However, although I support the existence of the ICC and deprecate those remarks, I do have quite serious concerns about some of the processes followed in this case, particularly in respect of the expert opinion commissioned by Mr. Khan to assist him in coming to a conclusion on whether to seek trials. And what they were asked to do was to conclude whether, quote, there were reasonable grounds to believe that the persons named in the warrants have committed crimes within the jurisdiction of the court. Now, these concerns of mine are founded on two things. Firstly, my own experiences as a chief prosecutor, and secondly, the important, I would say, essential question of prosecutorial accountability. And I'm making these remarks in front of a former Lord Advocate, and I'd be very interested to hear his views at the end. Who should make prosecutorial decisions and who is responsible for them? What's the proper status of outside legal opinions proffered to a prosecutor? Now, I stress very strongly that it's not unusual for prosecutors in England and Wales to seek legal opinions from outside their office in relation to the bringing of prosecutions. It happens all the time. Under our system, a prosecution is brought if the prosecutor concludes, one, that there's a realistic prospect of conviction on the evidence. This simply means that a conviction is more likely than not. And two, that the prosecution would be in the public interest. Occasionally, in serious cases, prosecutors in the CPS will send a case to a barrister in independent practice to obtain his or her view as to whether a given case had surmounted the first test, the evidential test, never the second test. The public interest test is always a matter for the prosecutor in consultation in the most sensitive cases with the Attorney General. So this is very common. Indeed, in my first year as DPP, I sent a case to a freshly minted young silk called Keir Starmer, precisely for that purpose. But prosecutors in this process are never bound by the views of outside lawyers in any circumstances. As it happens, I agreed with Keir's view, but I could easily have disagreed with it. And in that case, I'd have followed my own judgment without difficulty and put his to one side. And this would happen in the most serious cases. I received opinions from eminent silks, for example, in more than one case, that a death in custody should be prosecuted as murder. And I took over the decision and concluded that I disagreed and that no prosecution would follow. So even in the most serious cases, one would disregard an outside legal opinion without difficulty if one disagreed with it. But what was really going on in this case? And what was the real status of the expert panel? Can anyone doubt, in all these sensitive circumstances of this case, but that the prosecutor was bound to accept its conclusions? Let me be clear, I have the utmost respect for each member of this panel, and I know a number of them personally. They are people of the highest integrity, former judges, academics, eminent prosecutors. But just imagine, and it rather reinforces my point, imagine Karim Khan's position if he hadn't followed their conclusion. Imagine him trying to justify publicly that he'd sent this work to such an eminent group, but that now he'd seen their opinion, he didn't agree with it and he was going to reject it, particularly if it recommended charges against senior Israelis. There would have been absolute uproar. So this means, in my view, one of two things. Either he was commissioning an expert panel to rubber stamp his already concluded view, which can't be the case, since the panel was independent and they'd refused to accept such an instruction, or he was in effect and in reality handing over the power to make the decisive call to these outside experts, knowing that he would have no choice other than to accept their conclusion, whatever it may be. Now, of course, one can imagine all sorts of situations once they've come to their conclusion. There's the real world and there's the imaginary world. We all have real friends. Some of us have imaginary friends. But in the real world, I don't see any way that he could have rejected that conclusion. And if that's what he was doing, then I find the process objectionable because it's an abrogation of the role of the prosecutor, who is accountable to the international community for his decisions. The experts he commissioned, with very great respect to them, are in this context no different from private citizens accountable to nobody. There's a further point. If Mr. Khan was in fact granting the members of the expert panel the power to determine the course he would take in such a sensitive and politically significant case, the process of selecting the panel took on enormous significance. It should have been as transparent as possible and absolutely directed towards independence, both from his office, an important point, and obviously from the politics of the situation under consideration. Otherwise, there was no point to it. Again, I stress my respect for each and every member of this panel, but the fact is that two of them were existing special advisors to the prosecutor. Presumably, therefore, he was already well acquainted with their views and may have been able to predict with a degree of confidence what their conclusions might be. This is surprising to me. And two other panel members had previously expressed clear views in public about the situation in Gaza, as Joshua has pointed out in his unmissable Substack, and the behaviour of the Israeli government there in terms quite hostile to it. Again, this surprises me. Following publication of the report, all the members of the panel signed an opinion piece in the Financial Times, strongly critical both of Hamas and the Israeli government, and expressing the hope that further cases would be brought. Again, I express my enormous professional and personal respect and regard for these people. But I'm a little surprised that they did that, and in particular before any application to the court has been made. All in all, this process seems to me to have been unsatisfactory. Let me be swift on the principle of complementarity, because I'm not an international lawyer and I'll probably get this all wrong, but this is my understanding of the position. And I do know Israel, I know Israeli prosecutors, and I know Israeli judges. It's not at all clear to me that Israel has demonstrated itself incapable of investigating the allegations made by Mr. Khan. I've had dealings with Israeli public prosecutors, and I know them to be competent, professional, independent, and very tough. I had dealings with them when I was DPP, and that was quite a pleasant experience. I've also had dealings with them as a defence lawyer, and that's much less pleasant. In the past, they've brought charges against senior government ministers who've been imprisoned as a result of those charges, and they have the present PM under charges that threaten his political survival. No greater tribute could be paid to the toughness and independence of Israeli prosecutors, but that pro-Palestinian campaigners are seriously alleging that Prime Minister Netanyahu is continuing this war in order to protect himself from these very charges. In other words, the Israeli prosecutors are so independent and so tough that the only way you can defend yourself from them is to organise a full-scale war. This behaviour on their part is more than can be said for the record of many other prosecutors in democratic countries. Furthermore, the Israeli courts and the Supreme Court in particular are famously independent of the executive. And, as we've seen recently, that independence and its constitutional underpinnings have the most enormous public support in Israel. So, for my part, I would be very far from concluding that the Israeli state is unwilling to investigate allegations such as these. Mr. Netanyahu might be, but he's not the Israeli state. Still less incapable of doing so. I would say that Mr. Khan's action looks, at the very least, to be premature.
Thank you very much indeed, Ken, for that. We'll turn now, if we may, to Todd, who's going to tell us a little bit about the US experience with the ICC. My recollection is that the United States signed the original treaty, but it has never ratified it, and that's been the view of both Republican governments and Democrat governments. But it's also right that it's not entirely hands-off, if I can put it that way. In other words, its relationship with the ICC, to use a word much overused now, is nuanced. But Todd, anyway, be grateful if you would tell us a little bit about that.
Well, first, thank you very much for the opportunity to talk with you all and participate in this. It's a great opportunity. Yes, what you say is true. The U.S. has had a very sort of mixed relationship with at best, a mixed relationship with the ICC. It has I think what's fair to say is a long history of support for the principles that the ICC stands for: accountability, compliance with international humanitarian law, prevention of mass atrocities. These are all things that have received a lot of attention in the context of across administrations. But the relationship with the ICC sort of goes up and down like a sine curve. So the Clinton administration was a driving force in advocating that there should be some kind of international criminal court, but the kind of international criminal court that came out gave it great pause. Before that, in the lead up to that, the United States was a tremendous advocate for the War Crimes Tribunal at Nuremberg and Tokyo, for the Yugoslav and Rwanda tribunals, and a series of other ad hoc tribunals and other international criminal accountability efforts over time. Those tribunals that I mentioned all have one feature in common. We have many features in common, but there's one that you have to sort of focus on here is that none of them had the possibility of Americans being in the dock. And that then, and the product that came out of the Rome negotiations wasn't like that. And that put in place, against this set of values that the ICC stands for, that put in place this other thing that is, for better or worse, is true in the American body politic, which is a very, very strong desire, politically powerful desire, to prevent typically American soldiers, the idea of American soldiers being prosecuted overseas, which long predates the Rome Statute. It's, you know, if you go back and look at the negotiating history, the NATO Status of Forces Agreement, so we're talking 1951, what's driving it is the United States, and what's driving it is the thought that you can't, you know, you have to sort of see this from the point of view of an American politician. You can't have some, you know, some young American boy at that time drafted, sent off to some distant land and end up in jail. It's just not politically acceptable. So these two things are, it doesn't mean that the desire for accountability isn't true, it's that it's in conflict with something else that's also true. And that's the cause of the sine curve over time. It comes up goes up and down over time. It also goes up and down. The sine curve is affected by the political philosophy of the administration that happens to be in power. And you know, in general, you get more emphasis on cooperating with multilateral institutions in general, less emphasis on, you know, the rhetorical assertion of sovereignty. It's less of a rhetorical tool, and more importance, honestly, on accommodating the views of our NATO and other allies in democratic administrations than Republican administrations. And that's one of the things that the sine curve responds to. But the sine curve also responds to just particular things that sort of appear on the political horizon. So and that goes back all the way to the beginning. So that for, in the Bush administration, where there was a strong, strong disposition to being critical, to not accepting the International Criminal Court, and you saw in the Bush administration, in the early years of the Bush administration, you saw the unsigning, the so-called unsigning of the Rome Statute, the withdrawal of the American signature of the Rome Statute, the so-called withdrawal, the enactment of the American Service Members Protection Act, which had various restrictions on, prohibitions on the U.S. cooperating in any way with the ICC, and famously included a provision saying that if an American was ever taken to the dock and the ICC was ever imprisoned, that the United States had the right to use military force to free him, to sort of invade the Netherlands. It was called derisively the Hague Invasion Act. And we saw the conclusion of a series of agreements with over 100 countries, actually, that were designed to prevent the other country from ever transferring an American that they may have in custody to the ICC. And those were widely negotiated and concluded with many, many countries in the world, but not in Europe. No European country would accept that. So that was the political, that reflects the political philosophy of the Bush administration, you know, against the ICC. But lo and behold, what happens? And what happens is the genocide in Darfur. And all of a sudden the question becomes not a philosophical question of whether we like or dislike the ICC, you know, that's sort of a little bit metaphysical, but what are we going to do about this? And President Bush had taken a personal interest in the genocide in Darfur, and he basically decided that, yeah, I know I don't like the ICC, but this is really more important. This tangible thing is more important than the sort of political philosophy of opposition to the ICC. And lo and behold, we saw the United States start to warm towards the court, even in the Bush administration, and, you know, famously allow the Security Council to, for the ICC to exercise jurisdiction over the Darfur situation. It needed a resolution for the Security Council, and we facilitated that happening. And of course, it couldn't have happened without our over our objection because of our ego. We also saw the same thing in reverse in the Obama administration. We saw an administration much more predisposed to working with the ICC, trying to find a constructive relationship, working that out. We saw some amazing things happen. We saw the two most important cases at the time in the 2010s, in the years of the Obama administration, were cases against were cases in which, but for the United States, the ICC wouldn't have been able to investigate and prosecute. The United States was basically the engine of the arrest and surrender of the two people. And I can remember personally when I was a lawyer at the State Department getting a phone call one morning at 4 a.m. and one of these fugitives, Bosco Ntaganda, had walked into the U.S. Embassy and they were trying to figure out what to do with him. You know, and this was not a thing that we had a position paper on in advance. It's like, you know, I remember on the phone at 4 a.m., you know, the operations center's, you know, could you please repeat what you just said, because it was sort of unbelievable. And the United States worked it out in a way that I think it was fair to say that wouldn't have been possible to be worked out without our cooperation. And I do recall that a very senior ICC official telling me at one point that in fact, notwithstanding that the United States wasn't a party, there was no state in the world, no non-member or member, that had helped the ICC as much as we had in tangible ways. So there was that predisposition, let's say, in the Obama administration. But when it came to the end of the Obama administration and the ICC prosecutor said that it was imminent that she would commence an investigation of the situation in Afghanistan, which meant an investigation of allegations of American torture, responsibility for torture in Afghanistan, everything went cold. And it's not that there weren't people who would want to help, but the politics, the internal politics and the external politics that were such that it became, you know, basically impossible to move the relationship forward. That was the situation when President Trump came in 2017. So we had now Afghanistan, and we had an administration very predisposed to, you know, not in favor of sort of developing multilateral relations and so forth, and things, and leading eventually to the United States actually imposing IEPA sanctions against the prosecutor and one of her top deputies. IEPA sanctions like we impose against terrorists. And, you know, we froze their funds that were in the United States, which they weren't funds in the United States, but it affected their ability to use credit cards and things like this, you know, very pervasive sanctions. That was the situation still when President Biden came back in. And one of the first things he did was to repeal the sanctions, although even that, in the face of what was going on in Afghanistan, took a surprising amount of time before they could get that done. And that's where things stood. Not quite as bad as the Trump administration, but not really fixed yet. That's where things stood when two events happened that, you know, set the sine curve hurtling forward, upward. And the first was the new prosecutor, Karim Khan, announced that he was going to, and the word he used was deprioritize the portion of the Afghanistan investigation that involved the United States. He was going to focus on the Taliban, the allegations against the Taliban and Al-Qaeda. And that was taken, I think, rightfully as he's not going to come after us. And that let political oxygen start flowing back into the room. Then the second thing that happened was, stood as a true game changer, which was when Russia invaded Ukraine. And everything, you know, more than half of foreign policy became about dealing with that. And this, and the prosecutor was investigating the situation in Ukraine, which basically meant allegations of Russian war crimes in Ukraine. And there was an unleashing of political support from across the spectrum, so that in fact you had the Senate, the United States Senate, adopt a resolution of support for the ICC. You had actual changes in legislation to allow us to, remember that American Service Members Protection Act, to allow support for the investigation of the Ukraine that was otherwise impossible. And you had, there was a famous statement, Senator Lindsey Graham, who was a traditional, longtime critic of the ICC, said that President Putin had done what no one else could possibly have done. He had united the American people in favor of what the ICC was doing. Did accomplish almost an incomprehensible, impossible fact. So that was in fact the situation. It was in fact a very positive situation. And that was the situation when the events of October 7th happened, and leading to the aftermath and leading to the announcement of the request for arrest warrants. And the question for us, for the United States, really at this point is, to what extent is that, or is that not a game changer? Is there, how much oxygen is left in the room? How much is this going to send the sine curve hurtling to the, to the very bottom? And how much will supporters of the ICC be able to sort of get through this? Which then entails how much, so it's pretty clear that the United States is not going to help the ICC prosecute Prime Minister Netanyahu. But one sort of subsidiary question of that is, to what extent is that going to affect the way the United States does or does not support what the ICC is doing in other circumstances? And maybe, I'm sure I've gone over my time, but maybe we can talk about that a little bit as time goes on.
Yeah, well, thank you very much indeed for that, Todd. Can I just pick up a couple of points before we move to questions from those who are here and online? Complementarity. Guillermo, you were focusing on the fact that Palestine isn't in a position to prosecute anybody, and you explained why. Ken was focusing on the ability of Israel to investigate anything that amounts to a war crime and to deal with it through a system that is independent and adheres to the rule of law. Are you talking about the same thing, or are you... This is such a technical area that I just don't want there to be confusion.
I think we're talking about two aspects of the same thing. The fact that the Palestinian National Criminal Authorities do not have the legal authority to investigate supports the proposition, in my view, that they did not have the jurisdiction that was later transferred to the ICC, if the pretrial chamber is right. So that's one side of the argument. The other side of the argument is the principle of complementarity as a whole, and the relevance that it should have to the decision of the ICC. And there, I think, the court must take into account the fact that there are the national authorities of the country, which is not a party to the ICC, but it is in the picture, and they have to reflect on their willingness and ability, as Ken said, to conduct these investigations.
And that may be a contrast with Russia, where I think it would be a brave commentator to suggest that the prosecutors in Russia and the courts in Russia would prosecute President Putin or the senior military who are the subject of warrants
Doesn't seem very likely.
In the same way. I'm trying to be uncontroversial, but I think on that it's fairly straightforward.
Well,
but,
and whether he would provide the opportunity.
Yeah.
That's really the crux of the issue, whether the opportunity was provided.
Yeah.
Yes.
But Todd, you made an observation at the end that you hoped there would be a little bit of further discussion about something. So do you want just to kick that off now, and then we'll go to questions?
Okay. Yes, I was afraid to take up too much time. But now I'm
well,
involved
briefly then.
Yes.
I can be polite.
So what's the U.S. reaction? What has been the U.S. reaction about the ICC, and what does it tell us about what the situation is going to be like going forward? When the prosecutor announced the arrest warrants on May 20th, there were two statements, one by President Biden, a very short statement, and one short, but not quite as short, by Secretary Blinken, which were very critical. And one of them used the word, "This is outrageous." They talked about the false equality, the announcements of the request for arrest warrants against the Israelis and the Hamas leaders were at the same time. That they talked about the false equality of that. And they also talked about this failure to provide an opportunity to let the Israelis assert jurisdiction. And, or to say that, hey, these are cases that we can take. Under this principle of complementarity, we Israeli prosecutors, we'll have Israeli prosecutors look at this. And whether or not they will or won't, you have to give the opportunity. So that was a little bit, I think that was taken as harsh. But it seems to me, I'm on the outside, so I don't really know. I wasn't there sort of drafting it up. But we haven't seen announcements or indications that the State Department, the U.S. government, has shut down other areas of what had been ongoing cooperation with the ICC, including, we haven't seen statements that the administration is no longer going to support the ICC's efforts in Ukraine against the Russians. And those are no minor things. Those are not, in fact, easy things to shut off, no matter how agitated you are by what's happened with the Israelis. And if you look at Blinken's statement, Secretary Blinken's statement, it's a little sharp. I've seen sharper. I must say I've seen sharper. I worked in the State Department a long time. I've seen sharper. But its criticism is rooted in ICC concepts. It's rooted in the idea of in the ICC's own words. It doesn't attack the core principles of the ICC. It basically says you fail to meet up to live up to your own standards.
Well, and that's something which in due course the court has got to rule on, so we mustn't fall into the trap of anticipating what the court might say. The court is independent and will wade through all the submissions, no doubt, with joy.
There's one other important data point, trying to read tea leaves from the outside, like people used to try to read the pictures in Pravda about the Politburo. If you look at one of the prosecutor's tasks is to brief the Security Council on cases that have been referred by the Security Council to the prosecutor, one of which is the situation in Darfur, as I said earlier. And so the prosecutor comes every 6 months, I think it is, to brief the Security Council. And if you look at the statement that the U.S. government made, the U.S. mission made, which I'm sure was widely cleared, it looked to me just like a statement that would have been made, before all this Israeli stuff happened. It's very positive. It talks about the need for accountability, and states should cooperate with the ICC's arrest warrants in these cases, and the Sunnis should turn over the fugitives and things like this. So it was very positive. The other thing happening right now is there is in the Congress there is an effort, a bill passed by the House of Representatives to impose sanctions along the lines of what President Trump had against the ICC. And it passed in the House of Representatives, and it's been sort of bottled up in the Senate Foreign Relations Committee. And I heard yesterday a rumor that, and I don't know for a fact that it's true, but it's, in the world of probably true, that the chairman of the Foreign Relations Committee was going to allow a vote on the bill, I think next week. And, I don't know why that's happening. That could be because he's given up, because maybe there's political cost to sort of bottling up the sanctions bill, or it could be because he thinks he has the votes to defeat it. So one very important thing, if you're trying to sort of look for tea leaves to read, is to see if there is a vote next week, to see what happens with that vote and what happens with that bill. Because that bill, if enacted in the form that it presently has, would make it very difficult to be cooperative, no matter what the predispositions of the administration were.
Right, thank you. Well, I think we'll now move to questions. And what I would invite those who ask questions to do is, if you wouldn't mind standing and also saying who you are. And I'll start, Richard.
Well, thank you to the panel. My name's Richard Keane. I'm a member of the House of Lords, and I'm chair of the Legal Affairs and Human Rights Committee of the Council of Europe. Ken rather drew me in, so I have to make a minor correction. Yeah. I was for 5 years Advocate General rather than Lord Advocate, so I had no direct responsibility for criminal prosecution. But as a law officer, we reserved the right to seek independent legal opinion on complex and difficult issues. And as another member of the panel will be aware, I, as a law officer, reserved the right to strongly disagree with the conclusions they arrived at. However, the question that I have concerns the reference to Egypt, and I would be interested to know whether it's considered that Egypt, as a non-belligerent, could somehow be art and part guilty of a crime that was subject to prosecution by the ICC. I'm not at all clear about that, and I would welcome some views on that. Thank you.
Well, now, Emanuela, I think it was you that mentioned Egypt in passing, so would you like to take that?
Absolutely. So all states, whether or not they are parties to a conflict, have obligations under international humanitarian law, and when we're talking about the passage of relief supplies, neighboring states also have an obligation to allow and facilitate. The obligation is on the state. If we're looking at war crimes, so individual criminal responsibility, we end back in the complexities of what I was that I outlined when saying I think this is a difficult charge, even for Israel that has far clearer responsibilities and possible failings in what it did to allow and facilitate. I thought it was very unlikely that it had unlawfully impeded relief operations to the extent that it could amount to a war crime. So this is even more so for any possible Egyptian officials. We're talking about criminal responsibility. I think that Egypt as a state has important responsibilities under international humanitarian law. And that's an area that has been overlooked to a degree. And I think definitely in negotiations, it would be very important to also engage with neighboring states. And in this case, it's Egypt that is the most significant neighboring state in terms of improving the arrangements to let goods in and also to let people out.
Thank you. I've got 3 hands to pick up, but first, and forgive me, I should know your name, but I don't. But
Juliet Samuel, The Times.
I see your picture in The Times.
I've been on leave for a little while. I wondered, so most of you have expressed concerns about the decision to prosecute. I wonder what your views are on the integrity of the court in terms of, its judgments and other parts of this process, or whether you would have similar concerns based on decisions so far, whether you think there's still some, a core of integrity there that it would, in terms of, hearing and coming to any judgments.
Thank you. Do you want to have a go at that one, Guillermo?
Let's wait and see what the pretrial chamber decides. I mentioned that the Hungarian judge, Judge Kovács, had a very powerful dissenting opinion. I think it would be considered an excellent opinion by the standards of any legal system. And to be fair, the majority of the court was trying to strike a difficult balance. I don't think they got it right, but they had arguments and they reasoned and tried to justify their decision. The composition of the pretrial chamber has changed slightly. The Hungarian judge is no longer there. There's a new French judge, and the Beninois judge is still there. But I think it'll be interesting to see how they decided. I don't know. I wouldn't place a bet.
Todd, do you want to add anything to that?
I think I don't challenge their integrity. People have different views than I do, and I strongly think they got it wrong, but I don't challenge their integrity. It's not inconceivable to me that you could come up with a decision like that. I think that in general, the ICC prosecutor, understandably, tries to present to the world that we are just applying the laws to the fact. You'll hear the office say that all the time. We're just applying the laws to the fact. And the reality is the world's more complicated than that. It's all these questions that they have to decide aren't decided by the law. There's a huge element of judgment required to apply the law. So it's inevitable that they're going to do things that aren't illegal, aren't wrong, but that are things that are that can be disagreed with. And I think we have to sort of be careful about impugning their personal integrity without something more tangible than I don't like the way their decision came out.
Thank you. I think Joshua, your hand was up next.
Thanks, Joshua Rosenberg. I was actually going to ask a very similar question to the last one, but I will perhaps ask it in a different way. It was really what the panel thinks is going on in the court, because the prosecutor has expressed what I think one can regard as frustration in that there hasn't been a decision since he put in his request on the 20th of May. I think he was expecting a result more quickly. And so I was really going to ask the panel to speculate, despite your strictures. I don't suppose the court's going to take any notice of what's said here today. Speculate on what may be going through the minds of the courts, or possibly what should go through the minds of the 3 judges on the pretrial chamber.
All right. Well, now, rather than pick on somebody, is there somebody who would like to go first on that one?
Perhaps the former judge should speculate.
That's me. Well, I really don't know, but I would make one observation that nobody should underestimate the personal pressure that judges feel when deciding very difficult and high-profile cases. And looking at this from the outside, I really feel for the 3 judges in the pretrial chamber, who have to make this decision. Not only has the way in which the prosecutor has dealt with this been the subject of significant controversy, and I'm not going to enter into that, but also some pretty powerful submissions have been put in, not only by the third parties, but also by the prosecutor himself. And reading some of those submissions, although, as one would expect, they are achingly polite, they're actually rather critical of the court itself. So please don't underestimate the difficulty of the task that the judges have. I asked the question of Guglielmo at the beginning whether he had any idea of the chronology of what was going on, and your answer essentially was that you don't, and I'm not sure that anyone here does. But they've got some difficult procedural decisions to make as well. Are they going to deal with it all on the papers? Are they going to allow there to be an oral hearing of some sort? The position of the prosecutor articulated, if I remember correctly, in his written submissions, is that this is essentially an ex parte application and it's nobody else's business. But by allowing all these submissions in, the court has indicated that perhaps it doesn't agree with that approach, but how to manage them, I think is difficult, and so we're going to have to wait and see. Now, I think we've got a couple of minutes left. I think so. Daniel, I saw your hand up as well.
Thank you. Daniel Bethlehem, no corporate affiliation, member of the bar, but had some experience, or have had some experience of the ICC in a governmental role.
Just before you ask your question, I think many here will know that you were the legal advisor at the Foreign and Commonwealth Office as it was in those days.
Indeed, and had dealings with the then prosecutor and was involved in the process which led to his successor being appointed, and have had some involvement with the ICC since then. The title of this session is The Future of the ICC. And so far we've been looking at it solely through the prism of Israel-Gaza. All wars have to end, and accountability is addressed in different ways in different contexts. And my question, I suppose, to the court, and perhaps in the first instance maybe to Ken, because he will have sat in this seat and alluded to aspects of this, is what the panel thinks about a prosecutor of the International Criminal Court bringing down requests for indictments for arrest warrants in the middle of a conflict. As I've sort of thought about this, and I have to say I'm not going to declare my own view, and my own view straddles the question. But it's a little bit like a missile that's been launched, and we're now in the interregnum waiting for it to land. The possibility of taking arrest warrants off the table once they've been issued is exceptionally difficult and exceptionally political. And I raise this in the context of the future of the ICC because it seems to me that this is one of the big looming questions, and it's not a new question. I was in the Foreign Office when the issue of whether Gaddafi should be the subject of a referral to the ICC arose. And that question arose very sharply around political tables as to what that would do to Gaddafi's demeanor and the ending of the war. Now, let's just assume, for sake of argument, that Karim Khan, again, whose integrity I don't question, and I would align myself with Ken's observations there, but let's just assume that the arrest warrants for Gallant and for Netanyahu are issued. Where is that going to leave the process and those who would engage with the process? I mean, it seems to me that one consequence of that is that it will exclude European leadership from any future role of engagement with any shape or form of Israeli polity dealing with these issues, because Europe has set its face against dealing with those who are subject to arrest warrants. Now, I can see arguments on both sides of the equation. As I say, I don't express my own view, but I would be interested in a response on that and where this leads the ICC in the future. And perhaps I just add a footnote here. I think this question is relevant as well for an arrest warrant that was issued in respect of Vladimir Putin. It's not just an Israel situation.
I think, well, just before you answer, I think it's important to widen the question beyond Israel, even though, as I said at the beginning, that's the occasion for our debate. I mean, sooner or later, all conflicts end, often very messily, and they end, unless there's an outright victory, with a political compromise, something that might be a fudge. And so, I suspect, Daniel, that sort of what's at the back of your mind is if there are in due course negotiations about the Russia-Ukraine conflict, and the Russians say, well, look, we require all these arrest warrants to be lifted, otherwise we can't function. Where does that leave the ICC, and where does it leave the political process in trying to find messy resolutions at the end of very nasty conflicts?
And I would add to that, Ian, that the pathway to lifting arrest warrants is not at all clear. Article 16 of the ICC statute and the role of the Security Council is very, very challenging indeed. Let's assume, again, for the sake of the hypothesis, that Yair Lapid became Prime Minister of Israel in a future world. I imagine for Israel watchers that they would consider that it would be exceptionally difficult, even for a prime minister who had set his face against Netanyahu, to engage with an ICC over these issues. So I'm wondering about the political wisdom that informs a prosecutorial decision in these circumstances.
I think this is an extremely good question. And Juliet asked about the integrity of the court, and I agree with you, I wouldn't call that into question. I would frequently call into question its judgment, which is a different issue. We have an example to inform us, which is Uganda in the early 2000s, when the ICC unsealed an indictment against Joseph Kony and a number of leaders of the Lord's Resistance Army. There were peace talks going on in Kampala, and Kony said, we're not going to those peace talks unless this indictment is withdrawn. And the Ugandan government joined with the LRA, about the only time they did, in requesting that this indictment should be withdrawn, and the ICC refused, and the peace talks collapsed. So I think this is quite that's 20 years ago, but I think it's quite a nice illustration of what you're talking about. I was involved recently in a seminar involving people who had negotiated for the Russians and people who had negotiated for the Ukrainians, not now, but had in the past, in connection with the war. And my argument in that seminar was that I thought the ICC indictments against Putin and others were unhelpful. And I couldn't see what they were going to achieve in the context of that conflict. And to my surprise, the most senior Ukrainian in the room agreed. And the question is, can an indictment issued in those sorts of circumstances in the heat of battle be anything more than performative? And I suspect it is largely performative. The ICC went through a very difficult period when it was only prosecuting black people from Africa, and that did its reputation a great deal of harm, and it's tried in recent years to broaden this out. It's poked the British Lion and got a very snappy response. It's poked the American Eagle and got an even snappier response. And I get the impression it's sort of looking for places it can go to establish its universality, to establish its independence, its integrity, its freedom from racial, political, ethnic, whatever you want to call it, bias. But I think this is largely a performative process, and I think it is perfectly possible to conceive of circumstances in which it become a hindrance to the peace process rather than an assist to it.
Thank you. And I'm going to ask Todd to say a few words, but I'm also looking at Dean Godson at the back. We have run over time by a few minutes.
One more question.
One more question. So, Todd, a very short intervention on that, please.
I don't actually think it's just performative. I think it actually serves a purpose. Not that it's going to lead to will or won't lead to a criminal trial, but it's like a great travel ban. Netanyahu really cannot travel to Europe now, and Putin, notwithstanding the fact that he went to Mongolia, basically can't travel to, most countries. So I don't think it's just performative. I think this is in a way an example of the ICC making decision. The ICC's made its bet. It's going to. It doesn't consider the fact that the conflict is ongoing. That makes it off limits. It made that with the LRA, right? It's been that way. Almost all of those indictments in Africa were about ongoing conflict. So they've made their bed. They further made their bed with Russia, where it was very popular in the United States and the UK, what they were doing. And now we have to sort of see what does it look like when the sort of shoe is on the other foot a little bit. We're seeing it from the other side. I do think the ICC is going to continue to sort of play it out this way, that which is to say, the Rome Statute says that these are crimes that cannot go unpunished, and that's just the position they're going to take. And it will take something else in the international community to say you have to get off that track. And we don't know how that's going to turn out because we don't know how these cases against Netanyahu are going to turn out. But I do agree it can't go on forever like this. But I don't see the ICC pulling off. I don't see convincing the prosecutor not to issue arrest warrant, not to pursue arrest warrants in ongoing conflicts. From his point of view, forgetting about the specific context of from his point of view, he's sending out a message: you better stop. You better behave. You better stop doing this, or you're going to be in big trouble. He doesn't see that. He sees that as part of his main purpose. And in fact, for the most part, he sees Western countries applauding that. Right? We're happy when he issues those kinds of statements until now.
Thank you. I think we've got time for one more question. Dean, is that about right?
Yeah.
Right. There's a hand up. There's a hand up here.
Ed Stringer.
Oh, Ed's there. Sorry, forgive me. I've got lights in my eyes, and Ed, I couldn't see you there.
Thank you very much, Ed Stringer, now Senior Exchange. One-time Director General of the Defence Academy, and previously on a couple of occasions the National Targeting Authority. When I was a student at the Defence Academy in 2009, I remember spending a very good day in the Supreme Court in Washington, when the Associate Justice made a very spirited defence of why the US wasn't going to put its servicemen under the ICC. Very eloquent argument was made, challenged by the very multinational audience of Brits of the Royal College of Defence Studies who were there, many of whom, as you just alluded to, come from parts of Africa who felt they were being challenged. Since then, others, Hillary Clinton notably, have also justified staying out of the ICC on the grounds that it makes America much more vulnerable to lawfare. And part of the work I got, the first one involving policy exchange, thinking through lawfare. As a very general question, do you think the ICC, not least with the previous answer we just had, the ICC now looking to find other areas, prodding the UK and prodding the US, if I was a serviceman now, British serviceman looking 20 years ahead, should I be worried that the politics could change and things that I was doing now might suddenly become politically convenient to point at me and hold me in front of the court?
Thank you. Well, Emanuela, would you like to have if everybody wants a quick response on that?
As you were speaking, I would say, well, I want to make sure that the UK adopts policies and practices to ensure that all servicemen comply with international humanitarian law. It's not enough just to ratify the treaties. I think what we're seeing now is that it's very important to flow these down to operational guidance. So that should address some of the concerns.
There's a point that Todd made when we discussed this seminar and hasn't repeated yet, so I'll say because I think it's very important to both of the last two questions. The bar for decisions to request arrest warrant is probably too low, and it shouldn't be set where one would set it in the context of domestic crimes. And that is particularly the case when these arrest warrants are being requested in the middle of conflict. So I think there is a real problem there. And if you add to that problem the fact that they don't seem to have taken much notice of complementarity which for countries like the UK, Israel, is a key concern, then I think we do have a very serious problem. And I don't think anyone could sit here and reassure you that British servicemen in 10 years' time or whenever will be in the position where I think a fair reading of the rules should place them.
Thank you. Todd?
I think in the arrest warrant standard, which is reasonable basis to believe that a Rome Statute crime has occurred, might be too low in the midst of the conflict, but also in the midst of a case against a head of state, which we haven't really sort of talked about here, but is quite hard for me to explain. You know, the ICC has taken the position that head of state immunity is simply inapplicable in the ICC. And, you know, I can feel in my heart where that comes from, but I can't as a lawyer come to that answer. I don't really see how how a group of states can get together and say that the immunity owed to a head of another state, that's owed to another state, we're going to disregard it. They can do it among themselves because they've agreed to it. But, you know, the Russians would argue, the Israelis presumably would argue, we have never agreed to that. And this is a right under international law, and two other states can't compromise our right. That said, I think that you know, the risk of ICC prosecution is the kind of thing that's susceptible to a law professor making a lot of hypotheticals. You know, this could happen, there's a parade of horribles, but I think it's pretty unlikely. For the if you think about, well, you know, I know that the situation with Iraq here must have been very annoying more than annoying to a lot of people. If you think about the U.S. case, the charges that they were contemplating, they were not things for us to be proud of, right? They were some really dark days in U.S. history. So to me, the question was never really, are these, you know, they weren't made up charges. There were things there that should have been investigated more vigorously and weren't. But I don't really see, you know, given the limited resources, given the political conditions that they actually operate under in the real world, I don't see them, you know, I don't see it as a major, a significant practical thing to worry about, either in the UK or really in the US. I don't see us repeating anything like the torture episode that would put us in that kind of hot water again in my lifetime.
Ken?
Well, I think generally allegiance to an international rules-based order is weakening, certainly going through a period of retrenchment, which might be welcomed by some people in the room, but it's not welcomed by me. I very much agree with what you said, you know, about the standard for prosecution. I mean, I had several occasions when I was DPP in which we were invited to consider cases against British soldiers in Iraq, usually cases of murder. And I didn't authorise a charge in any of those cases. And the truth is, in one sense, we were applying a higher standard, but not because we were messing around with the code for Crown prosecutors, which mandates the test as conviction is more likely than not, but because we were factoring in the reality of being a soldier in Iraq with all the implications, all the threat, all the fear, all the danger, and that made it harder to reach that standard. So in essence, it was a higher standard for soldiers in that situation, in reality, and I think it should have been. I think that was right. But I think the weakening of allegiance to a rules-based order means that, and I regret this, as you do, soldiers may have less to worry about in that respect in the future. I mean, war crimes are war crimes, and they should be called out and prosecuted. The allegations against certain members of the SAS in Afghanistan are deeply concerning, and I've seen some of the evidence. They're deeply concerning. And the army itself, at the most senior levels, doesn't want this kind of behaviour, and it shouldn't. So I think it's very important that we don't lose sight of the damage that sort of behaviour does to the moral fabric of the nation, as well as the legal fabric of the nation. And I don't know a senior army officer that I've met who would say that war crimes should not be prosecuted.
Thank you. Well, I think that brings us to the time to draw this to an end, as we have overrun a little. On your behalf, can I thank our 4 panellists for their stimulating contributions, and can I also thank you for coming and also for participating. Thank you very much.